case briefs, and so much more. LSData's got what you're looking for.
In a 1989 Supreme Court case, Hoffman-La Roche Inc. v. Sperling, a group of employees sued their employer, Hoffman-La Roche Inc., for age discrimination under the Age Discrimination in Employment Act, ADEA. The employees formed a group called Roche Age Discriminatees asking Redress, R.A.D.A.R, to bring the charge. At the core of the case was the question of whether district courts have the authority to manage the process of joining multiple parties in collective age discrimination actions under the ADEA, and whether they can use their discretion to facilitate notice to potential plaintiffs. The issue arose when the court needed to decide if it could send a notice and consent document to all employees who had not yet joined the suit as part of the process of joining multiple parties in collective age discrimination actions under the ADEA. The case went to the Supreme Court to resolve the disagreement among the courts of appeals. The argument was based on a provision of the ADEA that allows an employee to bring an action on behalf of himself and other similarly situated employees, but only with written permission from each employee. Ultimately, the Supreme Court held that district courts have the authority and discretion to facilitate notice to potential plaintiffs in appropriate cases, as allowed by Rule 83, which permits courts to regulate their practice. The court had broad authority to control class actions and enter appropriate orders governing the conduct of counsel and parties to prevent abuse. The Third Circuit's judgment was affirmed, and the case was remanded for proceedings consistent with the Supreme Court's opinion.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.